Hi, I'm Rebecca Seiden with Sterling Healthcare and Life Sciences. I'm constantly impressed by how knowledgeable our clients are, but background screening can be really confusing. To help, I've compiled 5 common myths that I will debunk for you today. Myth number 1, conducting an OIG GSA check meets CMS requirements. Well, when a healthcare professional's license is revoked, which is the most common kind of exclusion by the OIG, it occurs on the state level. According to the CMS, any provider who's excluded in one state should be excluded in all states. However, there is no national database that tracks license revocations. So you should consider running a more comprehensive search that includes state Medicaid sanction lists, such as FACES 1M or FACES Level 3. Myth number 2, doing an enhanced nationwide search or searching the National Criminal Database is a sufficient criminal search. Well, the first point to make here is that a single national database containing all of the criminal records in the US simply does not exist. Records are actually housed by county, state, and federal courts. To add to that, courts do things differently in different jurisdictions. There are commercial databases that piece together the information, like the Enhanced Nationwide or National Criminal Database, but they have many gaps and they don't even cover every state. So these databases should only be used as locator tools in conjunction with an SSN trace to uncover where a candidate might have been convicted of a crime. Then, a county criminal search can be used to pull the conviction records at the primary source. Myth number 3. If a state has legalized marijuana for recreational or medical use, you must exclude it from any applicant or employee drug testing. Just because the state has legalized marijuana for recreational or medical use, it does not mean that you can't test for it. No state or federal law prevents employers from requiring that their employees are not under the effects of any substance while they are working. However, since legal protection for employees using marijuana varies quite a bit from state to state, it is important to understand the laws and to work with your legal counsel to have a clear policy in place for your organization. Myth number 4, reviewing the physical copy of an individual's license is considered a primary source verification. This is not correct. While it's understandable that a license itself would seem as much of a primary source as you can get, you can't tell from looking at the license if it is still in good standing. The license could have been revoked, suspended, impaired. The provider could be facing sanctions, exclusions, or disciplinary actions. This is unfortunately much more common than anyone wishes, and it's not always a result of medical malpractice or something related. A license could be suspended, for example, if the healthcare practitioner did not pay tuition or child support payments. So in a nutshell, for primary source, you or your screening provider will find the most up-to-date information on the board's website. Myth number 5, final myth. It is not possible to continuously monitor the status of board-issued licenses. Trying to monitor license statuses manually on a daily or weekly basis might not be feasible, but with advances in technology that automate the process, it becomes a reality. Technology allows us to track licensing board websites, data feeds, and other sources to identify changes to license statuses as soon as they occur. That way you can react right away, not in weeks or in months. All right, that's it for today. I hope you found this helpful and interesting. If you have any questions at all, we would love to help. Feel free to reach out to your client success partner directly or to our team at Sterling Healthcare at sterlingcheck.com. You can also find us at sterlingcheck.com/healthcare. Thanks so much for watching.